10, 2021 meeting of the Municipal Code Enforcement Board is now called to order. If everyone would please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on the evidence and facts presented this evening. Our meetings are conducted in accordance with Robert's Rule of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondent will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their name and address. Upon request, copies of materials submitted by staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the attorney for the city. At this time, I'd like to ask all persons who expect to give testimony tonight to please stand and be sworn in by the city clerk.
Raise your right hand. Do you swear or affirm that the testimony or evidence you are about to give or present is the truth, the whole truth, and nothing but the truth?
I do. Thank you. A couple of things. We do have a board attorney tonight. Mr. Jorge George Martin will be the board attorney this evening, and we are going to be taking one case out of order. Case number 20-4917, City versus, I'm going to mess up this name horribly, Bajita? Marifus Zaman will be taking that case first, and then we'll revert back to the original order. At this time, I'd like to talk about ex parte communications. If anybody on the board has had any ex parte communications, either written or verbal, please say so now. We'll start with you on the end. Mr. Gear?
No.
Had none.
None.
I've had none?
None. I've had none.
None.
Thank you. Okay, next, the approval of the minutes. Have all the board members received the minutes of January 13, 2021? Are the minutes acceptable? Are there any changes or additions? Seeing none, I'll accept the motion to approve the minutes, please.
I move to approve.
Second.
We have a motion and a second. All those in favor?
Aye.
Motion passes. Okay, on to the first case, please.
Case number 20-4917, City versus Bajita Mafia Zaman for the property located at 108 Oak Ridge Avenue. An affidavit of non-compliance was submitted by Officer Doug Allen for Section 828A1, dated January 14th, 2021. Bajita Mafia Zaman did submit a motion to dispute within the 10 days deadline on that, and so she is here to present.
Mr. Chair, if I can kind of, by way of introduction, you don't get this type of a challenge often. It's under Section 1-71 of the City Code. And what Ms. Zaman has done is challenged the non-compliance inspection report. So what's before you then is just a determination as to whether the violations were or were not corrected by the deadline date. That is what is being challenged at this point.
So not whether they existed, whether or not they were corrected.
You've already made the determination that the violations existed. You gave a deadline date and a fine. The non-compliance inspection report was issued, and she has challenged that within the proper time.
She's challenged the completion date.
Right, she's challenged she's saying the non-compliance inspection report is incorrect, that it was in compliance.
That's
the
at the
purpose.
at the date of the inspection, she was in compliance, even though the form says she wasn't.
Exactly. She's saying that she was in compliance at the time and no fine should be running.
Okay, thank you.
And Ernie, I do have the affidavit of non-compliance if the board would like that.
Yeah, I think.
We'll accept that, thank you. So who are we going to hear from first?
It should be the, Ms. Zaman?
And then whoever's going to speak, please state your name and address for the record, please.
Marfia Zaman, 108 Oak Ridge
I
Avenue.
don't think they're going to be able to hear you in the little box in the back. If you're comfortable, you can take the mask down and speak a little louder for us, please.
Marfia Zaman, 108 Oak Ridge Avenue. I want my uncle to speak on my behalf.
Okay, thank you.
Yes, sir. My name is Fakir Hussain of the same address. The city attorney has said that we are here to challenge the affidavit of non-compliance. That is not the case. We are not challenging that this is not in compliance or compliance. What we are here to report to you is that the order that we were given, that we understood the order to be, is not what ended up in the order. So what I mean by that is, at the time we came on December 11, when this case was first for hearing, we submitted to yourself where we were in the planning process and the design phase, and we advised that we are going to be able to submit the application before the next meeting, which is going to be on January the 14th, that we will be able to submit the planning application. So at that time, I mean, you hear so many cases, but we only have one case, so we know we are more intimately involved with this. So the chair suggested that given the progress or lack of progress in the design, if we needed more time, come back before the next date and request for an extension of time. But at that time, what I understood that we were to achieve by the January 14th is that actual formal submission of the application, not actually been already approved, because the city takes 6 to 8 weeks for them to review and complete an application before that can be approved. So there is no way we could have possibly been able to achieve this within January 14 days. And the only reason I didn't come beforehand to request additional time is because what I understood to be asked to do is to actually formally submit the application with the planning permission and everything else. But then it turned out to be actually a different order in a sense. It said, no, we have to be already in compliance by January 14, but that would have been an impossible task for us to achieve because the time that the city takes 6 to 8 weeks for a typical standard application to be processed. Now, I like to report you the progress in the meantime is I worked with the architect, I paid them extra. We had this application in even in December itself. The last day of December, we formally submitted this in. The city has already visited the site and they have asked us to make some smaller amendments, which in the process of being made right now. We're going to be submitting that in the next few days. So we're not sitting back, we're not being proactive, we're actively working. But this particular order, what we were told to do is go and try to get this application in as soon as possible. And if you need more time to put this in, come back and ask for more. Only reason I didn't come, like I said, is because we were actually managed to get the application in. So we're just at this point asking to allowing us more time for the city to complete this review process and be fully in compliance because we could not have been, it's not in our hand, it's now with the application with the city.
Okay, well, let me see if I can sum up your position. Your position is that your understanding was that you would have the submission into the city by a certain date, and that the order you finally got requested that you have full compliance by a certain date, and you're saying that that would be impossible to do because of the time it takes to review the application.
Yes, sir, because city
That
takes.
summarize your
Yes, sir.
testimony?
Yes, sir.
Okay. Thank you. Does anybody have any question for the witness?
Do we have anything that shows like the date that you submitted the application to show, you know, kind of exactly when you did all that?
Yes, sir. I submitted this on last day of December, 31st of December. But because the city doesn't entertain people coming in, so the formality is that you put it in the box. But within the 3rd or 4th of January, I got an acknowledgement that this has been received and being reviewed. So I can submit those emailed if that's being disputed to the city clerk tomorrow.
Is it with you?
I don't have it with me, but I can get it to her within next half an hour.
Deal with that in a minute then.
Yes, sir.
Yes, sir.
I may address the board. Again, Jorge Martin, and I'm acting as counsel for the board today. The vehicle that the violator has used to appear before the board today strictly limited to a challenge of the findings of inspection report. I think in this instance, you're going beyond that and you're challenging the nature of the order itself or the reasonableness of the order itself based on the time allowed. I wanted to point that out because that poses a procedural issue.
Yeah, and witnesses stated that they're not disputing with the violation.
Exactly.
So,
But that is the only cited provision for them to appear today. The board should be aware that that is, if that is the only,
So nor am I questioning the reasonableness of the order. Oh,
just
sorry.
a second. So maybe one of the, who's prosecuting this case as the,
This was done by Doug Allen, the inspector.
Doug, does the violation still exist?
Yeah, you did.
Yes, the
If
violation
he
is
could go to the
still-
podium.
Yeah, just come to the podium and state your name for the record, please.
Good evening, I'm Irani, city building official, City of Temple Terrace. Yes, there's still the violation outstanding, and this violation is on the existing home. Applicant has submitted an application. He wants to do the additional square footage or add to the existing structure, and that has been in question. So about 10 days ago or a week ago, I met with him at the site, and I explained to him, let's separate the issue. Let's focus on your violation and focus on the existing structure to get this cleaned up. And if you want to add to the existing home, that should be under the separate application or separate request.
Okay, so Jorge, if you, correct me if I'm wrong, but there's really nothing for this board to do because the violation does exist. And until the violation is cured or something happens, there's really nothing, I mean, we've already determined that that the property was in violation.
what the whole argument goes to is the reasonableness of the time in the original order. If that was an issue, it could have been challenged by review of that order, but not by review of an inspection report. The inspection report in and of itself is correct. The violation is not in
Cured,
compliance.
yeah, right.
Now, one of the things that the board can do is take that situation into account in later proceedings, for example, for a reduction of fine or some other treatment of the existing order.
But we can't do anything about that until the alleged violation comes into compliance.
That is what the code provides.
Right.
But sir, I'm not challenging the reasonableness of the order to achieve in the time. What I'm challenging is the recording of the order from what we were told versus what is in recording. What we were told is that go ahead and put your application in, and if you need more time, come back and ask us for more time. That's what I did before January 14th. So I'm not questioning this order itself is unreasonable. I'm not challenging the non-compliance. What I'm saying is what we were ordered verbally is not what is recorded. That's where the challenge lies. I think there's a fine difference between this.
Okay, well, here's where we are. There is an existing violation that has yet to be cured, okay, and you don't dispute that.
That's right.
There is really no decision for this board to make at this time until the violation is cured. At that time, or actually 35 days after that time, right? 35 days after that time, you can apply for a lien reduction, a fine reduction, okay? At that time, you would come back in front of us, state your case like you did tonight, and this board will entertain whether or not there should be a fine reduction based on the circumstances. Okay? Thank you. Sorry you had to come all the way down here. Next case, please.
Okay. We will take the first case under hearings, case number 24997, City versus Timothy Thibodeau for the property located at 113 Glen Ridge Avenue. Case is before the board based on alleged violation of section 128592, RVs, boats, and trailers. Case will be prosecuted this evening by Code Compliance Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were both properly served.
Thank you.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated by me on December 31st, 2020 regarding a non-commercial trailer parked in a driveway unscreened from view. I went directly to a notice of violation as the trailer had been on site for several days with no work activity observed at the residence. The NOV was prepared on December 31st, 2020 with a compliance date of January 8th, 2021. I posted the notice at the site as well as at City Hall, and copies were mailed both certified and regular mail to the address of the owner of record. My reinspection on January 26 showed no change, so I prepared a notice of hearing on that date, and the case was scheduled for the February Municipal Code Board meeting. This time I'd like to submit photographic evidence of the violations taken by me on December 31st and January 26.
We'll accept those, thank you.
Exhibit number 1 shows the posting of the notice of violation, and exhibit number 2 shows the trailer parked in the driveway. I've had no contact from the owner, and the site is not in compliance, and I'm seeking a ruling.
Thank you. Any questions for the code officer? Is the respondent here?
No, sir.
Respondent is not here. I'll entertain a motion since there is no questions.
I'll make a motion.
Thank you.
Thank you. In case number 20-4997, I move that the city has proven by greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 113 Glen Ridge Avenue. Code is section 12-859, subsection 2. This motion is based on the sworn testimony the board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, notice of violation, all of which is received and entered as part of the record of this hearing. I further move that said violation be corrected on or before March 10th. If the respondent does not comply with this order on or before that day, they are ordered to pay a fine for each of the every day the violation continues past the set date for compliance. Upon considering the following factors, the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine to be $25 per day.
We have a motion, do we have a second?
I'll second.
Any discussion? Seeing none, all in favor?
Aye.
Opposed? No nays, motion carries. Next case, please.
Since Officer Allen is already up there for sanitation purposes, we'll go ahead and take his next case, which is case number 20-6161. That's also City versus Timothy Thibodeau for the property located at 113 Glenridge Avenue. The case is before the board based on alleged violation of Section 10-3B, sanitation grass weeds. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were both properly served.
Thank you.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated by me on December 31st regarding overgrown conditions of a yard not being maintained or mowed. I left a door hanger with a reinspection date of January 6, 2021. My reinspection on January 11th showed no change, so a notice of violation was prepared on that date with a compliance date of January 18th, 2021. I posted the notice at the site as well as at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. My reinspection on the 26th of January showed no change, so I prepared a notice of hearing on that date, and the case was scheduled for the February Municipal Code Board meeting. This time I'd like to submit photographic evidence of the violations taken by me on January 11th and January 26th.
We'll accept those, thank you.
Exhibit number 1 shows the notice of violation posting, and exhibit number 2 shows the overgrown conditions. I've had no contact from the owner. The site is not in compliance, and I'm seeking a ruling.
Not in compliance as of this evening.
Yes, sir.
Thank you. Any questions for the code officer? Seeing none, I'll entertain a motion.
All right, I'll do this one. In case number 20-6161, I move that the city has proven by the greater weight of the evidence the following violations of the City of Temple Terrace Code exist on the property located at 113 Glen Ridge Avenue. Applicable code section is 10-3 subsection B. This motion is based on the sworn testimony this board has received from Code Enforcement Officer Doug Allen, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that said violations be corrected on or before March 10th. If the respondent does not comply with this order on or before that day, they are ordered to pay a fine for each and every day the violation continue past the date set for compliance. Upon considering the following factors: the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine be $25 per day.
We have a motion, do we have a second?
Second.
Motion and second, any discussion? Seeing none, all those in favor?
Aye.
Opposed? No nays, motion carries. Next case, please.
We will jump to the last case under hearings. Repeat case number 210345, City versus Janice L. Murphy for the property located at 9239 Overlook Drive. Cases before the board based on alleged violation of Section 12921, parking residential property. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were both properly served.
Thank you.
Good evening again, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case is a repeat violation of case number 20-2410, which came before the Code Board on July 8, 2020. The property was brought into compliance prior to the hearing, and no fine was assessed on that date. January 20th, 2020, I observed vehicles continuing to park in the yard area left of the driveway. A notice of repeat violation was prepared on that date with an immediate compliance date. I posted the notice at the site as well as at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. My re-inspection on January 27th showed no change, so I prepared a notice of hearing on that date, and the case was scheduled for the February Municipal Code Board meeting. This time, I'd like to submit photographic evidence of the violations taken by me and Director Baroni on January 22nd through February 10, 2021.
We'll accept those. And just a point of order, you had originally said that you had visited the property on January 20th, 2020. I believe you meant 2021, correct?
Yes, sir.
Thank you.
Exhibit number 1 shows the repeat notice of violation posting. Exhibits 2 through 9 show vehicles parked in the yard area, and exhibit number 10 is the July 8th, 2020 order of finding. I have had contact with the resident on January 28th and provided information on how to bring the site into compliance. The resident did expand the parking area, but did continue parking in the yard area on 2 different occasions. Site was out of compliance for 10 days, and we were requesting a $50 per day for the 10 days it was out, for a lump sum fine of $500. The site is in compliance. I'm submitting an affidavit of compliance, and I'm seeking a finding.
Thank you. Any questions for the code officer?
Yeah, you said they expanded the parking area, is that?
Yes, sir.
So they added some concrete or?
Gravel. The driveway is a typical 2-car driveway, so that would always park on the left-hand side of the driveway area, which is probably equivalent to 2 to 3-car driveway. And they had some gravel in there at one point in time, but it basically was indistinguishable. And that's when I met with him and told him exactly how many yards he needed to get, where he could get it, and how much it generally would cost him to get it, and what he needed to do. And they did do that, but for whatever reason, after they put the gravel down, there was at least 2 different occasions that now they were parking on the right-hand side of the driveway. But in the last few days, they have...
Gravel dirty.
Yeah. The last few days, they've been parking either in the driveway or on the gravel.
Are they in compliance?
At this point, yes, sir, I submitted an affidavit of compliance.
Okay.
But there was 10 days when they were out of compliance.
Yes, sir.
Bill?
And you suggesting
that the fine be $500 at this point.
Yes, sir. A lump sum fine for the 10 days it was out of compliance.
Any additional questions for the code officer? Seeing none, I'll entertain a motion.
I'll make a motion.
Thank you.
In case number 21-0345, I move that the city has proven by greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 9239 Overlook Drive. This motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, and notice of violation, all of which is received and entered as part of the record of this hearing. Further move that the respondent be found to be a repeat violator as defined by City Code Section 1-63 because the respondent has been found to have violated the same provision of the City Code within previous 5 years, regardless of property address. I further move that the daily fine be assessed for the repeat violations from the time of the notice of the repeat violation till the time of the repeat violations have occurred, upon considering the following factors: the gravity of the violation, any action taken by the violator to correct the violation, and any previous violations committed by the violator. I move that the total fine amount be $250 or $25 a day for the 10 days that they were out of violation.
Or a motion?
In
Do I hear a
violation,
second?
sorry.
Second.
Any further discussion?
Just curious, is there a reason why you didn't want to accept what the recommendation from the code compliance officer?
Yeah, I like the 25 more. I think 500 is quite a bit, considering that they have made efforts to, remedy the situation in the past. It's one of the 3 criteria we're to judge by. If there's no progress, I just personally think 25 is better for me as well, given those factors. Nothing personal, of course, to anyone, 50.
Any further discussion?
We, as I understand,
One at a time, please.
as
go
I
ahead, Rod.
understand, the code enforcement officer has their formula for that.
Right.
So we went from, I got lost for a little bit. We went from $500 a day to $25 a day.
Yeah, so they suggested 500, and I made a motion for 250.
Yeah.
So, we're up here to
Yes.
make a judgment, or else we wouldn't be here. So, that's what we're up here for. And, I made the motion.
I really don't have a problem with that. I think
Yeah.
it's reasonable.
Yes, I think his suggestion is fine.
Yes.
Any further discussion?
Well, I think you clarified my suggestion or the suggestion. Oh, okay, yeah.
Any further discussion? Seeing none, all in favor?
Aye.
Aye.
Opposed? No nays, motion carries. Next case, please.
Case number 2060, okay. We will go with case number 20.
Oh, thanks.
6111, City versus Rod A. Hamill for the property located at 6125 East 110th Avenue. Case is before the board based on alleged violation of Section 10-3B, sanitation grass weeds. Case will be prosecuted this evening by Code Compliance Officer Lori Smith. City has evidence that the notice of violation and notice of hearing were both properly served.
Good evening, Mr. Chairman, board members. Lori Smith, Code Compliance. This case was originated by Director Baroni on December the 29th, 2020. My inspection revealed a temporary yard sign in the front yard and the rear grass was overgrown. At that time, I left 2 door hangers with a reinspection date of January the 4th, 2021. My inspection on the 8th of January 2021 revealed the yard sign had been removed. However, the rear yard grass was still overgrown. Therefore, a notice of violation was prepared with a compliance date of January the 18th, 2021. No one was at home, so I posted the notice at the front door and requested copies be mailed both certified and regular mail to the address of record. I also requested a copy be posted at City Hall for the 10-day requirement. My inspection on January 22nd, 2021 revealed no change. At this time, I would like to submit photographic evidence that was taken by me on the 25th of January 2021 showing the violations.
We'll accept those, thank you.
Sir. Exhibit number 1 shows a notice letter posted at the front door. Exhibit number 2 shows the overgrown grass in the rear yard, the east side of the property. Exhibit number 3 shows the overgrown grass, weeds, rear yard, the west side of the property.
Is the property currently out of compliance or in compliance?
As of today's date, the site is not in compliance, Mr. Chairman, and I am seeking a ruling.
Thank you. Any questions for the code officer? Seeing none, I'll entertain a motion.
In case number 20-61111, I move that the city has proven by the greater weight of the evidence the following violation of the City of Temple Terrace Code did exist on the property located at 6125 East 110th Avenue. Applicable code section 10-3, subsection B. This motion is based on a sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavit, and the notice of violation, all of which is received and entered as part of the record for this hearing. I further move that this violation be corrected on or before March 10th, 2021. If the respondent does not comply with this order on or before that day, they are ordered to pay a fine of each and every day the violation continue past the date set for compliance. Upon considering the following factors, the gravity of the violation, any action taken by the violator to correct the violation, and any previous violation committed by the violator, I move that the fine be $25 per day.
Second.
Wait till I call it.
Oh, I'm sorry.
We have a motion. Do we have a second?
I'll second.
Thank you. Any further board discussion? Seeing none, all those in favor?
Aye.
Opposed? No nays, motion carries. Next case, please.
Twenty 6077, City versus Bessie A. Mathis for the property located at 8009 Peach Drive. Cases before the board based on alleged violation of Section 1034, sanitation, keep premises clean. The case will be prosecuted this evening by Code Compliance Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were both properly served.
Good evening, Mr. Chairman, board members. Jose Silva, Code Compliance Officer. This case originated proactively on December 23rd, 2020. During my inspection, I observed a mattress on the ground of the open carport of the residence. I left a door hanger with a compliance date of December 28, 2020. My inspection on January 4th, 2021 noted no change, so I submitted a notice of violation with a compliance date of January 15th. No one was home, so I posted notice at the front door of the residence as well as City Hall. Also mailed copies, both certified and regular mail, to the address of the registered owner. My inspection on January 15th, 2021 found no change. The mattress was still on the carport, ground of the carport. This time I have two exhibits I'd like to submit: the notice posted at the front door and the mattress on the ground of the carport.
We'll accept those. Thank you.
As of today's date, the property has come into compliance, and I'm just looking for a ruling. I have an affidavit of compliance.
We'll accept that. Thank you. Any questions for the code officer? None, I'll entertain a motion.
In case number 206077, I move the city is proven by a greater weight of evidence the following violations of the City of Temple Terrace Code did exist on the property located at 8009 Peach Drive, Code Section 1034. This motion is based on the sworn testimony this board has received from Code Enforcement Officer, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move there be no fine imposed because the violations were brought into compliance prior to the date of the hearing.
Or a motion, do we have a second?
I'll second.
Motion and a second. Any further board discussion? Seeing none, all those in favor?
Aye.
Opposed? No nays. Next case, please.
Are we gonna take a minute just to get set up? I think we have to move like people around.
Okay, sure, we can, if we need to take a break, then let's take a couple minutes and let's come back at, let's say 20 after.
Are we really expecting this to be very long?
Yes.
I remember the last one.
Okay. All right, let's reconvene, please.
Case number 210256, City versus K&W Property Group for the property located at 8903 North 78th Street. The case is before the board based on alleged violation of Section 12768A1, tree unlawful removal, Section 12768A2, tree removal standards, and Section 12768B, tree removal and development. The city has evidence that the notice of violation and notice of hearing were both properly served. The case will be prosecuted this evening by City Attorney Pamela Shishon.
Thank you.
I don't know whether to talk from there or from here.
Wherever you're comfortable.
The city is ready to proceed this evening with the prosecution of these ordinance violations. I believe that the defendant or the respondent has counsel here. Mr. Singer is at this table. I don't know if he has any preliminary things he wants to bring up, but we are ready to start.
Okay.
So.
Good evening, Board. David Singer, 101 East Kennedy, Suite 2800, Tampa, Florida, for the respondent. I would certainly invite the city to begin. I will tell you I am holding in my hand, which I will present to the board attorney, an affidavit appointing me the agent for the respondent so that I may appear before you this evening.
Thank you.
I'd like to start by doing a brief opening statement. I know this is a little bit different than our usual cases, but there's probably more evidence in this and more witnesses to present on this particular case than usual. This particular case involves a vacant lot in the city of Temple Terrace on North 78th Street, and we intend to present witnesses to establish that unlike the previous case that some of you had heard, this does not involve a single-family home with one property owner who cut down one tree. Instead, this was an empty lot owned by K&W Property Group, and over 20 trees were clear-cut on this property. At least 11 of them our city arborist will testify were considered grand trees, and he'll explain to you how he made that determination. We are anticipating that the defendant is going to try to use a Florida Statute 163.045 as their defense. And it's a very short statute, as you may recall, doesn't give much guidance at all. But our contention and we believe our evidence will show that the statute was not complied with, that the documentation provided by the arborist to the property owner does not address the property in question, and that it does not adequately address what occurred on the subject property. We also will contend that the statute does not apply to this particular property at all. At that, I'm ready to call my first witness, and that would be Jose Silva.
Good evening, Mr. Chairman, board members. Jose Silva, Code Compliance Officer. On February 4th, 2021, I completed an amendment notice of violation and notice of hearing for irreparable, irreversible violations. Posted the notice at the owner's residence and at the gate entrance to the property. At this time, I'd like to submit 3 pieces of evidence. The notice posted at the front door of the owner's residence on 2/4/21, the notice posted at the gate on 2/4/21, and an aerial of the property appraiser's website showing the parcel.
We'll accept those.
And we're going to try to do this a little more formally tonight, so before that is accepted, I need to provide copies of these to opposing counsel and provide copies of these to the clerk once they are accepted, so if we can go just a little bit slower.
We're going to give them exhibit numbers or anything?
So I am.
Okay.
I do intend to do so. So first, I'm going to refer to Exhibit 1A for identification. And I'm going to show this to Mr. Silva and ask him if he just say, can you identify what 1A is?
1A is the original, contains the original packet for the original notice of violation that I completed on January 15th, 2021.
And was this originally served on the defendant?
It was posted at the property at that time.
All right, and then after that, did you then prepare an amended notice of violation?
Yes, I did.
At this time, we would like to introduce Exhibit 1A.
Accept that, thank you. Just go that way and then come back.
Yes.
Mr. Silva, I'm going to now show you what's been marked as Exhibit 1B for identification and ask you if you can please identify that.
Yes, ma'am. This is the second notice of violation, notice of hearing that I prepared on February 4th, 2021.
And what was the difference between the first violation notice and the second violation notice?
The difference was it was a city code that was not in the system that had been added. It was in the Muni code, but when we created the original notice of violation, you couldn't pull that code up because it was not entered into Navaline yet.
Okay, and was that ordinance number 12768B?
Yes, ma'am.
And did you also remove a particular ordinance in the amended in the amended violation notice?
Yes, ma'am.
And was that because we felt that that did not apply to this particular case?
Correct. The permit application required.
Okay. City moves to admit Exhibit 1B.
We'll accept that, thank you.
And now I'm going to show you it's been marked as Exhibit 1C. And ask if you can please identify that.
This is the posting of the notice at the respondent's residence on the 4th of February.
City moves to admit Exhibit 1C.
We'll accept that, thank you.
I do have one copy of this particular one.
Okay.
This is the one we already looked at.
Thank you.
And Mr. Silva, in addition to posting at the door, and whose door was that?
This was the respondent's residence at 6804 Bluffs Boulevard is what the property appraiser has as the owner of the property. K&W Property Group LLC.
Okay, and is one of the managers living at that address?
Yes.
Okay, and do you know who that is?
By the original notice of violation, the registered agent was CC'd on the bottom, which is, excuse me, I'm gonna butcher this name, Halafa Khalid, registered agent is 6804 Bluffs Boulevard, Tampa, Florida, 33617.
And I'm now going to show you Exhibit number 2 for identification, if you would please tell us what that is.
Exhibit number 2 is the second posting at the property gate on February 4th, 2021.
And does it also show the posting of the original
Yes.
violation?
If you look to the right of the center post, that is the original posting of the original violation, and then the notice of hearing is to the right of that one.
City moves to admit Exhibit number 2.
We'll accept that, thank you. Thank you.
Silva, you testified already that you had obtained an aerial view of the property. And where did you get that aerial view?
From the Hillsborough County Property Appraiser.
Okay. And did you print that out?
Yes, ma'am.
Okay, I'm gonna show you exhibit number 3 for identification. And is that the aerial you're referring to?
This is the aerial. The red outline is the actual parcel.
City moves to admit exhibit number 3 into evidence.
We'll accept that, thank you.
And Mr. Silva, did you ever have any contact with the property owners or the property owners' managers?
No, ma'am.
And was this the conclusion of your involvement in this particular matter?
Yes, ma'am.
Thank you. I have no questions for this witness. The defense counsel.
He's going to get a chance to cross if he likes, right?
Mr. Silva, no questions. Thank you, sir.
That's what I was waiting for, sir.
We were all waiting for it, thank you. I wasn't sure if you're going to wait till everybody was done or you're going to do them individually, so, okay.
City calls its next witness Amir Anisi.
Good evening.
Just sure I know the answer to this, but they were all sworn in at the beginning, right?
Yes.
Okay, thank you.
Mr. Anisi, would you please state your name and your position with the City of Temple Terrace?
Sure. I'm Amir Anisi, building official, City of Temple Terrace, and Community Development Director as well, too.
And how long have you been in that position?
As a building official and the director, I would say 4 years.
And do you hold any certifications or licenses from the state regarding your job? Yes,
I have multiple. As a matter of fact, I have building official certification, I have plan examiner, and I have inspector certification too.
And in the course of your employment, have you met with any of the representatives of H&D Property Group prior to October 1 of 2020?
Yes, I have.
And what was the purpose of your meeting with them?
It was a pre-development conference back in August of this year. We met with the property owner and his associate and a consultant agent, so talking about the potentially developing this property.
And what did they want to do on the property?
Well, based on their request and the meeting they requested from us, they want to develop this property and build, multifamily dwelling unit or townhomes on that parcel.
And do you recall how many they wanted to build?
Well, that was part of the main discussion. They told us they want to put close to 46 unit, and we advised them based on the current land use and density, they are not allowed to do that because it's zoned and is for future land use they have R9. We told them maximum unit they can put in that 3 acres is 27. So part of the discussion, we told them they need to go through the Planning Commission and Hillsborough County for comp plan amendment and changing the future land use in order to get the higher density and having more unit.
And do you know whether they ever did that?
Based on what we heard from their consultant and their agent, yes, they done it. They went through Hillsborough County Planning Commission application process, and they went before the board. They got approval for changing the future land use, And that's pretty much is a letter of recommendation to us, and ultimately we have to take this before our council for adoption.
And currently, is this property being put to any residential use?
No, it's a vacant land, however, is zoned as a multifamily, residential.
And when you say vacant land, there's not any residence on there at this time at all? Correct?
No.
If someone wants to develop a parcel in the city, is there a city ordinance that tells them what they need to do in order to remove trees on a lot?
Yes, it is.
And what needs to be submitted, if anything, regarding the trees on the site to get an approval to build?
Typically, part of the requirement process is a topographic boundary survey of the property to show all the element on the vacant piece of land, such as trees, the size of the trees, the number of the trees, and then and the consultant typically provide a table, tell us exactly the number of the trees, the location, and what needs to be removed as part of the development.
And I'm going to show you now, and these exhibits are now going to be out of order, but the numbers are really for the clerk's benefit and not to be concerned, you should not be concerned with it. This is exhibit number 21 for identification. And I'm going to ask you whether that is the city ordinance that pertains to tree removal for intended development.
Yes, it is.
And if you'll look at 12768B, what is required in order to remove protected trees in conjunction with development?
Well, again, as I said, part of the requirement would be a documentation of topographic boundary survey given to us. So knowing what's the size of the trees, and then once we receive that information, we have certified city arborists. Part of our staff would review what has been submitted, and then ultimately determine based on this section of the code what needs to be done in order to remove the trees.
At this time, city would move to admit exhibit number 21 into evidence that has the statute that Mr. Anisi is referring to, and also is the entire section of the statute that was cited in the notice of violation.
We'll accept that, thank you.
There should be a copy for everyone there. Okay, take one back though. I'll make it through the night without tripping on the wires. Did H&W Property Group ever submit any sort of development plan to the city?
No, they haven't. At the time we had a conference meeting with them in person, they provided a copy of a concept plan. And again, that was not officially, submitted or attached to any official application for development.
Was that what they provided to you during your first meeting with them when they told you they wanted to build more than was allowed on the property?
Yes, that was the prime reason. I believe we had a conference with them in order for them to understand how many units they are able to build and what needs to be done as a roadmap moving forward to develop this piece of property.
And at any time, did H&W Property Group submit a tree survey to the city?
No, they have not.
Now, if someone is following the whole procedure and they're submitting their development plan with a tree survey, what happens if there are trees in the way of where a developer wants to build?
Well, ultimately, based on the city arborist review of submittal, ultimately we have to mitigate if a tree is in the center of the development or is in the location needs to be removed. So ultimately, yes, we will mitigate that tree removal.
And if there are, on their survey, if there are dead or diseased trees shown on the survey that are in the way of the construction, does the city still require that those trees be replanted or paid for?
No, the only healthy trees, they're subject to mitigation. Dead trees or diseased trees, if again is confirmed by city arborist, that does not need to be mitigated.
Now, as an empty lot, did the property that was owned by H&W Property Group have an address last year assigned to it?
No, it did not have.
That's all I have at this time for this witness.
Mr. Nisi, I have a few questions for you.
Sure.
Could you repeat for the board what the future land use designation on this property is?
R9 currently.
And is that a residential designation?
Designation typically fall under the zoning, not under the land use. Land use typically deal with the density.
What does the R in R9 stand for?
Residential.
Thank you. What is the zoning on the property?
Multifamily, I believe so, RMF.
And so in a multifamily designated parcel, could you have an office there?
We have to look at it under the land development code. I'm not sure. We can explore that option.
Could you have an industrial facility under multifamily designation zoning?
And again, I got to go through the code section in order to answer your question.
Could you have a residential set of units on a multifamily residential zone piece?
You could, yes.
Thank you. Mr. Nisi, are you aware that code section 12768, which was submitted by the city, is not in compliance with Florida statute 163.045?
Object.
And again, I'm
This is
not.
outside the scope of the witness's knowledge.
Board, he has testified that he's an expert and that he is familiar with tree codes, and if he's familiar with the city tree code, it would be incumbent on him to be familiar with state statute as well.
You're asking him,
Calling for a legal opinion.
The only issue that this raises the capacity of this witness to reach legal decisions. This has not been a witness that has been tendered as a legal expert. So, again, based on the board's discretion, if you accept any testimony on his knowledge of statutes, there should be a caution that it should not reach the legal sufficiency or legal aspects of that statute.
I'm going to sustain the objection based on him not being an attorney.
Understood. And Mr. Nisi, I withdraw the question.
Sure.
At one point, you said dead and diseased trees could be removed on a residential parcel if it is confirmed by the city arborist that they are dead and diseased. Is that correct?
Yes, it is correct.
Thank you. No further questions.
Any redirect?
Mr. Anisi, when I asked the question about dead or diseased trees and whether they required mitigation, did you understand that I was referring to the requirement under the submission of a development plan and under our development code?
Yes, again, part of the development, the developer and their consultant, they have to provide us with that document, part of the submission, stating that, yes, this tree, again, has been examined by their arborist or by their consultant to be, diseased or to be dead, and based on that information, because we don't typically walk in any property to determine the trees. So developer has the obligation to provide that information for us to review it and make a determination.
If I may redirect as well, if you're done, Mr. Cohen. Could you point out in the city code where it specifies that the city arborist must sign off on a residential piece of property where there are dead and diseased trees to be removed?
Well, again, part of the development, you're required to provide that information.
Sir, I'm asking
And
if you
that-
can point out the code provision that requires.
Well, again, we have a qualified staff on the board to make that determination. We are not questioning the section of the code who is responsible to review that. Part of the development package, you need to provide such information for us to make that determination.
Sir, where in the code does it specify that?
Well, again, once you submit it, somebody has to be certified in order to look at that qualification. So you would ask somebody is not qualified as a city arborist to review your document? That's what you're saying?
No, sir, I'm simply asking, point me and this board, the code provision, where it says the city arborist must review dead and diseased trees on a residential piece of property.
Well, again, I mean, you submit a document to the building department or community development to get reviewed. Somebody has to be qualified to review that documentation. You would expect a city arborist would review your document, not the planner, not the inspector, not somebody doesn't have any qualification to look at your documentation. So,
I'm so sorry, I may not be
The
being.
city will concede that it isn't a part of the ordinance, that this is a procedure and a process we use, not that it is a part of a law that the city has.
I apologize. Sir, could you point to me a document that the city has that requires that the city arborist review dead and diseased trees on residential property?
well, again, the ordinance is clear. How you're able to remove the
Board
tree,
members, I'm
how
sorry,
you
Counsel, I have to object. Ms. Chacon just said it was not in an ordinance, and she stipulated that, and now the witness is saying it is in the ordinance.
No. Look at the ordinance. It says that in order for you to remove a tree, you got to go through the certain process. You got to go through this procedural. This is part of the procedural for the department. Now you're questioning why city arborist is looking at your document. My response to you is, this is the qualified person has to review what you're submitting in order to removing your trees.
Sir, I'm not asking you to interpret the substance. I'm simply asking
I'm
you
going
to
to
point
object that we're now, it's been asked and it's been answered to the best of his ability. Now we're badgering the witness.
Board, I would ask you to find here that it is not in the city's ordinances or any written document that any city arborist must review dead or diseased trees on residential property.
We'll take that into consideration. Thank you.
Thank you. I have no further questions for the witness.
No further questions for this witness. The city will call its next witness, Joseph Ferris.
Good evening, Mr. Chairman, members of the board. Joe Ferris, City Arborist, City of Temple Terrace.
Okay, and Mr. Ferris, how long have you been the city's arborist?
3 years.
And are you certified by the International Society of Arboriculture?
I am.
And do you have a copy of your certification with you?
I do.
And if you could, if you'll show that to opposing counsel.
Thank you, sir.
And I'm going to ask you if you can identify exhibit number 20 for identification, state what that is.
That's my certification card from the ISA that shows my certification and expiration date and my Florida number.
City would move to admit exhibit number 20.
We'll accept that. Thank you. Thank you.
Thank you, Bill.
Mr. Ferris, in the course of your employment with the city, did you have the opportunity to visit the property at 8900, or excuse me, 8903 North 78th Street last year?
I did.
And what caused you to do that particular inspection?
I received an email from a resident that was dated December 10th. She had sent the email around 2:20 in the afternoon. Wanted to bring to my attention excessive amount of trees being removed off of 78th Street. Had looked online, didn't find any permits, so wanted to bring that to my attention.
And did you look to see if there were any permits for tree removal there?
I did,
And what did you find?
that we hadn't issued any.
And after you did that, what did you do?
After that, I responded to her that I would take a look into it. I went to talk to Amir, my supervisor, to let him know that we had a complaint about some trees along 78th, and I was going to go take a look at it.
And once you went to the property, what did you find?
I found from standing on the right-of-way on 78th Street, there were several massive piles of trees, and then there was a truck back there with something going on. Couldn't tell if it was cutting or what was going on. Looked around the property, saw that there's a fence and a farm-type gate that was unlocked. I then called Tom Baroni to verify whether or not I had the right to walk on the property to find out what was going on. He explained to me that as long as there was no posting, that it was a private property, no trespassing, that I could walk on the property. So I walked into the back property towards the north end of the property, and there was a tree service there, on-demand tree service. We were doing stump grinding. I had asked them what they were doing. They said they were hired to stump the grinds. I said, did you remove the trees? They explained they were not the service that was hired to remove that. I then walked around the property taking pictures of just ground level of the removal and the debris that was there. I then spoke to the gentleman that was running the crew that they were going to have to stop. That I was putting a stop work order on. At that time, when I first walked up, they were almost done with one stump. They had started another. I said, finish that, but no more. You'll have to stop for the day.
Were you provided with anything at that time by anyone on the property to indicate that an arborist had made any determination about any of the trees on the property?
I was not.
And when you looked at it, were there stumps or the remains of stumps that you could determine had already been ground down to sawdust?
There are a couple areas that appear to be piles of sawdust, what it looks like after you've stump grind, and of course the ones that they were finishing.
How many stumps still remained on the property?
At that point, I didn't know the number. It wasn't until the following day that I got the numbers.
And after you issued the stop work order, did you do anything else on the property that day?
Not that day. I came back to the office. I put the stop work order in the system.
And I'm going to show you several documents that have been marked as city's exhibit number 4. And what is that?
This is an image taken from 78th Street, so the west side of the property. 78th runs north and south.
Did you take, hold on a second, did you take that photograph yourself?
I did.
Okay. And does it accurately represent what you saw on the property?
It does.
Okay. City moves to admit exhibit number 4 into evidence.
Accept that, thank you.
Go on, describe what that says.
Again, so I was along 78th. I wasn't on the property at the right-of-way, and I was able, in the image, obviously you can see back in the property there are several large piles of debris from trees that were removed. And towards the center of that, there is a truck that was there, which is what I assumed where the crew cut into the trees.
And I'm now going to show you what's been marked as city's exhibit number 5 for identification.
Before you submit that, we probably ought to make a correction here. There's no way, the date of this photo says 12/10/21. We should probably get something on the record that corrects that. There's no way.
Did you prepare this exhibit?
Yes.
Okay, and where it says date of photo, is that the correct date that you took this photo?
No, that should be 12/10/20.
20,
Yes.
okay. So I've shown you exhibit number 5, and did you take that photograph as well?
I did.
Okay, and does it accurately show what you saw on the property?
It does.
Okay. City moves to admit exhibit number 5.
We'll accept that, thank you.
And if you could explain to the board what that depicts.
This image was taken in the center of the property, looking toward the southeast, showing one of the debris with quite a large trunk of a tree that had been removed.
Okay, so, again,
And again, this was on 12/10/20.
okay, so all the pictures are gonna have the same issue?
Yes.
Okay.
Probably.
I believe so. I'm now going to show you what's been marked as exhibit number 6 for identification. Did you take exhibit number 6 as well?
I did on 12/10/20.
Does it accurately depict what you saw on the property?
It does.
City moves to admit exhibit number 6.
We'll accept those, thank you.
And you can please state why you took the photo. What does that show?
This was taken again from the center of the property looking north. You can see there's a couple of piles of what appears to be fresh mulched stumps, and the stump grinders in the back working on one of them at the time.
I'm going to show you what's been marked as city's exhibit number 7 and ask you what date did you prepare that exhibit?
I did.
And what should be the correct date of that photo?
12/10/20.
All right, and does that accurately represent what you saw on the property?
It does.
City moves to admit exhibit number 7.
We'll accept that, thank you.
And if you can please tell the board what that depicts.
This photo is taken from the north side of the property looking east, showing another large debris of tree removal.
I'm going to show you city's exhibit number 8 for identification and ask you whether you also took that photo.
I did take this.
And does it accurately represent what you saw on the property?
It does.
City moves to admit exhibit number 8. With the date of the photo was what?
12/10/20.
City moves to admit exhibit number 8.
We'll accept that, thank you.
And I'm going to show you what's been marked as city's exhibit number 9 for identification. And did you take that photo?
I did.
Okay, and what date did you take that photo?
12/10/20.
And what does that depict?
This is a picture from the east side of the property looking north, showing a couple of the large stumps and the debris in the background.
City moves to admit exhibit number 9 into evidence.
We'll accept that, thank you.
I'm now going to show you exhibit number, what's been marked as exhibit number 10. And did you take that photo?
I did.
And does it accurately represent what you saw on the property?
It does.
Okay, and what date did you take the photo?
12/10/20.
And what does that show?
This is another photo taken from the east side of the property, looking east at one of the large piles of debris.
City moves to admit exhibit number 10.
We'll accept that, thank you.
All right, you said that you went to the property on the 10th, and then you issued the stop work order. What did you do the next day?
The next day, I went back out with a notepad, measuring tape, and went along and measured each of the diameters of the trunks, sort of kind of a rough sketch of where they were located. Got photos of each of those with the measurements.
And how many trees did you finally find had been cut on the property?
When I went back on the 11th, there were 26 stumps, minus the 2 that had already been stump grind at the time I stopped them the day before.
And you said you took measurements. Why did you measure the stumps?
In order to determine what the breast height, the diameter of the breast height would have been, I needed to get measurements of the diameter of the trunk.
Why is it important to determine the breast height of the tree?
To be able to determine the replacement value of the trees for mitigation purposes, or in this case, for penalties.
And is that a number that is in our ordinance that is required, that you're required to have? The number that equates to the breast height of the tree?
In terms of?
I mean, why do you use that calculation?
The breast height is determined when it comes to mitigation of trees. 5 inches or greater are protected. So there's a formula, a set formula for the certain sizes. Between certain numbers would tell you how many trees it would take to replace that particular tree if it's been removed.
When you examined the stumps that were there, were you able to determine whether those were freshly cut trees?
Yes.
And are you able to determine the health of a tree from a stump?
Not completely.
And what were you able to determine, if anything, from examining the stumps of these trees?
The majority of the stumps all were fresh hardwood, no indication of decay. Very few, if any, small minor cavities, but nothing of rot and decay in the center of the tree.
And what is a grand tree?
A grand tree, according to our code, our ordinance, is anything over 24 inches in diameter measured at breast height is considered a grand tree.
And is the definition of grand tree included in our ordinance?
It is.
And I'm going to show you what's been marked as City's Exhibit Number 23 for identification, and ask you, what is that? What is this document?
This is the definition section of our code.
And as it pertains to trees?
To trees, yes.
City moves to admit Exhibit Number 23 into evidence.
We'll accept that, thank you.
I don't have enough copies for everyone there.
Okay. I'm gonna have to read it and share it.
And what is a protected tree?
A protected tree is any tree over 5 inches in diameter at breast height, and a particular species of tree.
For example?
For example, live oaks, laurel oaks, pine trees, most palm trees, sycamores, crepe myrtles, they're all considered protected trees.
So after you did your measurements on the stumps, what calculations did you make and why did you do that?
The calculations made on the stumps, I used the penalty formula that's in our code to determine the amount of trees it would take to replace that particular tree.
And is that something that you do in the course of your job generally?
Not in terms of the penalty formula, no. Just in terms of normal mitigation.
And would normal mitigation take place if someone wanted to develop a piece of property?
Yes.
And how does that work? What is your job when it comes to review of development plans submitted to the city?
On a particular property like this where they're going to develop that, part of what they would submit is a landscape plan that from engineer, architect, whomever does it, showing how many trees, showing the exact location where they're affected based on what they're developing. They would then provide the sizes in those ranges according to the chart that's in our code and give me the numbers that are required to mitigate. I would then come into my office, I review all that to make sure the math and everything is correct.
And did you perform that type of calculation did you ever perform any calculation based on the trees that were removed as if you were doing it for a development plan?
I did on this after doing the calculations for the penalties. I went through based on that diameter at breast height to do a comparison of how many trees it would have taken to mitigate under normal process compared to having gone through and removed them without the normal process. And then, of course, the cost associated with both.
And so if the property owner in this case had come in with a development plan and a tree survey, what did you calculate would have been the cost for them to remove all these trees?
In a normal process with the mitigation, based on the 26 trees that they had removed, it would have taken 311 trees to replace those at a cost of $300 per tree with a total of $93,300 in mitigation fees.
So now, is it possible to plant 311 replacement trees on a property that somebody's going to put townhomes on?
It's not, but that number can be reduced based on how many trees they're able to plant on the site. So if they have 311 trees, and they can only plant 3-inch DBH, then that 300 then would be paid into the tree fund. So that number, the total number of trees that are required to replace what they removed can be reduced by the number that they replant on the site.
And you said you also did a calculation based on if someone was going to be penalized for removing trees without a permit. And what was that calculation?
According to the formula for a penalty, it was a total of 3,296 trees to replace the 26 they removed. At $300 per tree, coming to a total of $988,800. $988,800.
You said 3,600 trees?
3,296.
196 trees.
And did you find, after you did all this calculation, did you make any contact with the property owner?
At that point, I sent an email to the property owner notifying him the removal of the trees, copying in our code section of the penalties, how it's figured out in the total number required replacement and the penalty fee.
And when you gave him the penalty, did you tell him it was $988,000?
Yeah, the total of 9,809, yes, that total. Our code does specify the minimum of 50% of the cross-section of the trees are required to be relocated on the site. So the actual penalty was then half of that $988,000.
And Did the property owner or anybody representing the property owner ever contact you with regard to what had been done here?
No,
At any time were you provided with any documentation that they claimed would allow them to do this?
yes, let me find that email. Sorry. On December 11th of 2020, I received an email, and I don't know if I'm pronouncing the name right, Waldid, W-A-L-I-D, I believe is one of the property owners or developers, who sent me a letter with an arborist attached report for the property.
And what was the date on that document from the arborist?
That was dated October 26, 2020.
And did it have a property address on there?
It did.
Okay, and what was the property address on his letter?
8105 North 78th Street.
And what was the address of the property where you found all of the tree stumps?
At the time of the 10th and the 11th of December, there hadn't been a physical address assigned to this property as of yet. According to property appraiser, it just said North 78th Street.
Okay. And eventually, what was the address assigned to this property?
The address that was assigned was done on January 12th, 2021 with 8903 North 78th Street.
So then the address on the letter from the arborist was some other address?
Correct.
And the document that was given to you then was that signed by a certified arborist?
It was.
And did it list 26 trees and identify them in any way, saying that they were a danger?
It did not.
And was the word danger used on that document anywhere?
It was not.
And it did say something about that some tree would pose a risk, correct?
Yes.
And what did it say it would pose a risk to?
To property and persons.
And did it say what property or what persons?
It did not.
Okay. And on the date of that letter, was that property vacant?
It was.
And, oh, okay. And again, you said it did not use the word danger, correct?
No.
Okay. But it did say something about a risk.
Mm-hmm.
And, let's see.
Hazardous
A risk to what?
A hazard risk to newly built home.
And was there any newly built home on the property?
There was not.
After you received that, what more did you do with regard to this, if anything?
There wasn't anything more.
Did you happen to examine that aerial photo of the property that had been admitted into evidence?
I did.
And based on that and the remains of the cut trees, what category of property was 8903 North 78th Street under our ordinance 12768 subsection B? As far as wooded or semi-wooded?
It would have been a wooded site.
And is there specific requirements as to the permits or how to remove or how much you can remove from a wooded site?
Yes, for a wooded parcel, 35% or more of the canopy, that's what determines. I don't have that with me. I believe it's 30% of the trees are allowed to be removed on a wooded site.
So then, subsection B of 12-768, that it's been admitted into evidence, does that apply to varying types of properties?
I believe so.
And you made a determination that this particular one was wooded.
Yes.
And when you are reviewing a development plan and a tree survey, if there is a dead or diseased, dangerous tree on the property, is the property owner required to mitigate that particular tree?
If the tree is dead, meaning completely dead, there's no leaves on it, it's 100% dieback, I don't require mitigation for something like that, no.
Were you eventually made aware of a second opinion from the same arborist?
I was.
And once you received the second opinion from the same arborist, did it turn out that according to him, there were more grand trees on the property than you originally thought?
Yes.
Is there any way that you can determine whether the ones on the list were cut or not cut?
I don't have any way to determine that without a proper boundary survey.
Did you find any dead trees still remaining on the property?
There is one to the east side of the property that butts up against Meadowwood condos that is 100% dead.
And in your opinion as a certified arborist, would that dead tree present a danger to persons or property?
It would, with its close proximity to Meadowwood and the units that butt up against the property.
Yet you said that one's still there.
That one's still standing.
What was left?
A various amount of live oaks, some laurels of different sizes, mainly just around the property edge. And I take that there's also two large ones in the center of the property they did leave. The front end of the property wasn't touched at all. There are a few trees up there as well.
And as a certified arborist, if a tree has a defect, does that mean that it's a danger?
Not necessarily, because it depends on the defect. A defect could be a rotting limb that could be mitigated to remove, that would eliminate the threat or risk of danger to a property or a person. Because of just a simple defect, again, every tree is different, it depends on what the defect is. Just to say a plain defect isn't enough for justification for a complete removal of a tree.
And if a tree has some loose bark, is that present a danger to persons or property?
No.
If there's some insects boring in it, does that necessarily present a danger to person or property?
Again, it depends on the tree, where it's located. Is it next to a property? And what's the extent of the insect infestation?
Of the stumps that you examined, tell me again, how many did you look at?
26.
And from the stumps, did you find anything that you could tell from the stumps was a dead, decayed, diseased tree that should definitely have come down?
No, everyone I looked at was solid hardwood, completely pale color as they were just freshly cut. No sign of any rot or decay.
And what are you trained to do as an arborist when you encounter a tree with a dead or diseased limb on it?
The first thing you want to do is determine what you can do to mitigate that limb or those limbs to try to preserve the tree. You don't want to just jump to removal on a single or a few limbs. And again, it all depends on the tree.
And I'm going to show you what's been marked as City's Exhibit Number 22 for identification, and ask you to please identify this.
This is the dead tree that is on, this is facing the west side from Meadowwood. So the tree would be on the east side of this property along that property line that is 100% dead.
Okay. And does this photograph accurately represent what you saw on the property?
It does.
Okay. And when were you on the property to view this particular tree?
This one was this afternoon.
City would move to admit Exhibit Number 22 into evidence.
We'll accept that, thank you.
I believe that's all I have for this witness at this time.
Mr. Ferris, thank you. That was very thorough.
Okay.
You seem to be very familiar with the property.
Mhm.
Would you remind the board what the future land use of the property is?
That I'm not familiar.
You don't know?
No.
Would you remind the board what the zoning of the property is?
I'm not a planner, so I wouldn't know that.
You don't know?
I'm an arborist, so I don't get into the zoning.
You don't know the zoning or the future land use?
No, that's not part of my job description.
Thank you. Mr. Ferris, you testify that you've been the city arborist for 3 years?
Yes.
So you started in 2018?
I started with the city in 2017. I was certified in 2018.
Was there any change, to your knowledge, in how the state deals with trees, and specifically the removal of dead and diseased trees on residential property in 2019?
Yes.
And what was that change?
That would change stated that a residential property, if they found danger to the property or person, the tree could be removed.
You say they. Who's they? If they
Property owner,
if the property owner found?
I assume.
You assume?
Just a second.
Sure.
Thank-
Again, this witness has not been qualified for his legal knowledge.
I cannot hear you. Yes, I just can't hear you.
This witness has not been qualified as having expertise in law to the extent that he knows about law changes, content of a statute, that is fine, but the substance and effect of law should not be taken as an expert.
Well, he can certainly testify to his understanding of.
Here, I have it here, if you'd like me to read it.
No, sir, I would
Okay.
not need you to read it. I was just curious if you would familiar.
It says property owner. Property owner.
What is it that says property owner?
It says the removal of a tree on a residential property if the property owner obtains documentation from a arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect.
Sir, what, can you tell us what you're reading from?
I'm reading from the statute itself,
What statute?
163.045.
Did you read it from the beginning?
Okay, tree pruning, trimming, or removal of residential property. A local government may not require a notice, application, approval, permit, fee, or mitigation of pruning, trimming, or removal of trees on residential property if the property owner obtains the documentation from the arborist certified by the International Society of Arboriculture or Florida licensed landscape architect that the tree presents a danger to persons or property.
Thank you, sir. That's
Okay.
all my questions.
You direct? All right, thank you.
That concludes the city's presentation.
Board, if you'd like to take a few minutes to take a breath and stretch your legs, that is fine with me. If not, we can proceed. It is totally up to
Take
you.
a couple minutes? Yeah. Okay. Why don't we take 2 minutes and we'll come back. Or 4 minutes, whatever it takes.
You didn't
Right,
know what to
let's
sign
get-
on for.
Let's get back as fast as you can. How's that?
Depends how long that bathroom line is.
Yes. It's not getting any earlier. Counselor?
I'm ready, Board.
Okay, all yours.
I'll remind the Board for the record, David Singer, for the respondent. We just heard a very thorough presentation from the city attorney and the city witnesses. I will be much more brief, but no less informative. And the city has everything I'm going to show you. I sent via email to the city attorney earlier today. I'm sorry I don't have enough copies, but it's just the statute and the arborist report. I'd like to start by showing the board.
We probably should start by showing Jorge.
Sir, I don't need that, but if you have an extra copy of the
I'll read it all to you when I'm finished if you don't mind.
I understand.
I have 2 copies, so I will start one on each side.
Thank you.
What you see before you, Mr. Ferris had read aloud. And I will read aloud again because it is extremely pertinent and in fact controls this situation. It is Florida Statute 163.045, and it is titled Tree Pruning, Trimming, or Removal on Residential Property. And before I read the language, I will remind you that several city witnesses testified that the zoning and the land use on this piece of property is residential. Again, the title, Tree Pruning, Trimming, or Removal on Residential Property. Number 1, a local government may not require a notice, application, approval, permit, fee, or mitigation for the pruning, trimming, or removal of a tree on residential property if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect that the tree presents a danger to persons or property. That is what the statute says. There is nowhere in the statute that says an arborist report must be submitted to the city arborist for review. There is nowhere in your code that said a private arborist report must be submitted to the city arborist for review. What I will show you next, and again, I have 2 copies. Report from the arborist. What you see in front of you is a 2-page report.
Excuse me, are we asking that these be admitted into evidence?
You know, I'm not that formal, so whatever you think.
Well, it needs to be made part of the record. We are making a record, though, so a copy does need to go to the clerk.
I am more than happy
If
to.
it's being admitted into evidence.
I'm more than happy to submit that as Respondents Exhibit 2. Respondents Exhibit 2, on the letterhead, says O'Brien's Tree Service and Stump Grinding. It is dated October 19th, 2020, and it reads, I, Edward O'Brien, certified arborist, was asked to evaluate the trees on the residential property located at 8903 North 78th Street, Temple Terrace, on October 19th, 2020. Of the 43 trees I inspected, I found 15 of them to be in good health, have proper branch structures, and free from visible disease or decay. The other 28 trees I would consider to be in poor health, hazardous, and in my opinion, presenting a danger to persons and property for the below reasons. And he then lists the trees and the reasons. He is a certified arborist. I will point you back to the statute that very clearly reads, A local government may not require a notice, application, approval, permit, fee, mitigation for the pruning, trimming, or removal of a tree on residential property if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture. I will ask to be entered into the record as Respondent's Exhibit 3. This is the certification of Edward O'Brien as a certified arborist by the International Society of Arboriculture. To be admitted as Respondent's Exhibit 4 is an affidavit from Edward O'Brien verifying everything he wrote in his report that is marked as Respondent's Exhibit number 2.
I haven't seen that yet.
And if you would pass a copy to council when you have reviewed it. Let me see if I have an extra one for council. I do. I note that this was emailed to council earlier today.
Thank you.
While the presentation here tonight by the city was very thorough, it failed to take into account that state law explicitly preempts any type of action against a property owner removing trees from residential property if they have a report from a certified arborist. It does not say that report needs to be submitted to the city. It does not say those trees may not be grand trees. All it says is if the trees, in the opinion of the arborist, are dead, diseased, a danger to persons or property, they may be removed without requiring a notice, application, approval, permit, fee, or mitigation. That is exactly what happened here. The reason that the state government enacted this statute was to avoid situations exactly like this. It is completely preempted from local purview. This board does not have jurisdiction to issue any fines against the property owner. If you have an issue, if council has an issue with the report of the arborist, you must take it up. No, Ms. Chacon, no. Ms. Chacon, this is my time. You gave your time. I did not object.
Just one at a time.
This is a time for presenting the case and the evidence and the witnesses.
That is exactly what I'm doing.
I have seen no witness here yet.
There doesn't need to be a witness because the case is so simple.
That's in your opinion.
That's in the state government's opinion.
This seems to be a closing argument right now. This is a time for them to present their witnesses
Board members,
and
come
any
on.
testimony they have. I haven't seen a single witness, and it seems that counsel is doing the testifying here.
I am
He's
here on
presented a
behalf
bunch
of the respondent. I gave you an affidavit.
You'll get your chance. Just get, when she's done, you'll get your chance.
A bunch of documents. We object. We'd like to pose an objection to an affidavit being submitted because an affidavit cannot be cross-examined.
It's certain notarized. If you have a problem with the arborist, go after the arborist.
No court of law accepts just an affidavit.
This is not a court of law.
Some evidence rules need to apply here.
No, they don't, counsel. And your counsel should instruct you to that. The rules of evidence do not apply in this forum.
I cannot cross-examine, and so I do object to the affidavit being submitted.
So noted, thank you.
Board members, your city attorney can object all that she wants. We have followed the statute to the letter. There is no purview that this board has.
Before you continue, do you plan on calling any witnesses?
Of course not.
Okay.
There are no witnesses that need to be called.
So if he's not calling any witnesses, I would assume that, Pam, you'd like to do a closing argument before he does, or do you care?
If he wants to make his closing first, first, I guess that's where we are now, and I'll make my closing last.
That is completely fine.
Okay.
Board members,
Floor is yours.
This is extremely simple. There is a statute. There are particular requirements within it. All of those requirements have been met. Based on the plain, clear language of the statute, this board may not impose any type of mitigation or fee requirement or fines on the property owner. I understand that it is frustrating, believe me, that these trees were removed, but you have the report from a certified arborist that said they pose a danger to persons or property. So if there is an issue that this board has, perhaps it's with the veracity of the arborist report. That is not the fault of the property owner, and you may not penalize the property owner for that. The other group you may have a problem with is the state legislature. They enacted this statute. It doesn't mean we have to like it. It doesn't mean that we have to cheer for it. It does mean that we have to follow it. It is that simple, and nothing else tonight matters other than you following the language of the state statute. You may not find any other way. It is completely out of your purview. Thank you.
Before you go on, Pam, if appropriate, Jorge, I do have a couple of questions.
Please.
You gave us this letter from Everett O'Brien dated October 19th, 2020. And he says he inspected the property at 8903 North 78th Street. I thought I heard testimony that said that there was no address given to this property until January 12th, 2021.
I heard an 8105 was another
Yes,
address.
and there was an 8105, but this clearly says 8903, which apparently that's the ultimate address. But I'm just wondering how he knew what the address was before it had an address.
I got the same question.
I don't know. It is the affidavit of the arborist that is sworn before a notary, sworn under oath.
I have a follow-up question.
Sure.
Yeah, your presentation was perfect and very clear and very simple. But you said that if we had any problem, maybe it could be the veracity of the arborist. Well, of course, that's exactly what I'm thinking. Of course, anybody with common sense would say that a little bit because it's so different than what our arborist was saying about how the trees looked. Now, when you put that in context of the date right now, that makes me think that even more. Now, your argument is perfect, but the truth of that statement, I don't know about that.
Let me remind you that it is not the responsibility of the property owner to provide this to you. Nowhere in the statute is it required.
Any other questions? Pam, the floor is yours.
Actually, this one dated October 19th. Is this the original arborist statement? Or is this the follow-up, like the affidavit confirming what he wrote?
That is the arborist statement.
The original.
That the affidavit verifies.
Okay.
Thank you. Our case does not depend on an arborist or a property owner or anybody submitting anything to us ahead of time. We're not contending that that's what the statute requires or that we require. We understand that this bad statute exists, and we are dealing as best we can with it. So the continuous claim that it doesn't require that anything be submitted to us to review in advance is true. We agree with that. That's not the problem. Common sense, regardless of this statute, must still be used in considering this case. And common sense stands to reason. Just like if you get stopped for driving without and gets ticketed for driving without a driver's license, you are still in trouble, even if 3 months later you go and get your driver's license. Here, we had trees cut. It appears that maybe, because the only thing that was provided to us initially was the October 26th letter from the arborist. talking about going to a property address that isn't even anything like the address of this property. It's not just off a number, it's just off. So, the statute says that the property owner has to obtain documentation. We contend that at the time that the trees were cut, and they were discovered cut in December the 10th. At the time that the trees were cut, no documentation existed with regard to that piece of property. I don't have an arborist here to question as to why this mistake is here, or whether he was just on some other property and his report pertained to something else. But initially, this is what we were given. Had this letter that we were given actually said that 26 trees were a danger, and that's what the statute says, presents a danger to persons or property. What we were given says nothing about a danger. It says a risk to a newly built home.
Sorry to interrupt, but has that document been?
That's the letter from October the 26th.
Have we seen it?
I don't know.
I haven't seen that one.
There hasn't been.
It's sitting there on council's
Your
desk.
document that you sent to me that I have no evidence pertains to this matter at all. It's the wrong address. It has nothing to do with this matter.
Well, it's signed by the certified arborist, Edward O'Brien, and the testimony of Mr. Ferris was he was given this documentation by the owner. And that's what he testified about, that it poses a hazardous risk to a newly built home, and that nowhere on this does it say anything about a danger. That's why.
Before you go on, I am more than confused right now. So you have a letter in your hand dated October 26th that is unaddressed.
No, it has an address.
Has
It
the
says
wrong address.
8105 North 78th.
Has the wrong address. Okay.
It has a very wrong address.
Now, he submitted into evidence a letter dated October 19th.
Which was emailed to me, and although I hate to be testifying, but as an officer of the court, it was emailed to me by counsel well after us citing his client.
We're not obligated to provide it. We're just showing that the owner had it, which is all the statute.
I don't know that the owner had that. The owner isn't here either. So I don't know where this came from, and oddly, you can look right at its face. It's dated October 19th. I don't know whether the owner actually had this at the time, and you don't know whether the owner had this at the time. So we contend that this isn't much of a defense to the ordinances that were cited.
Okay.
And oddly enough,
Can anybody explain why our arborist was giving an October 26th letter and not this when he asked for something?
I have no idea. There could be any number of reasons, including mistake, including hitting a wrong button on an email. We've all done that. I have no idea, but it has nothing to do with this matter.
it has everything to do with this matter, because we gave the property owner a chance to come forth with his documentation. And if he had had the documentation, there would have been no citation. We would have left.
Get the documentation.
We would have left. It's used as a defense. He tries to argue to you that it totally preempts us doing anything, that we can't require any permits as long as somebody comes up with this documentation from an arborist. And yes, if it's proper documentation, if it fulfills the statute and the common sense, that's fine. But we don't have that here.
There's no evidence in the record that this is important.
And there is nothing in this, if you look at the statute that he's provided you with, I don't see the word preemption anywhere written in that statute. And they like to argue that it preempts us from doing anything. We've got a whole development code that you heard about tonight from Mr. Anisi and from Mr. Ferris. It applies to situations where people like this property owner want to come in and develop a multifamily property. It even says that in our ordinance. If the intention is to develop multifamily, this is what you must do. And it doesn't include going on some backhanded way of clear cutting the whole middle of the property out. So it appears that even though they were on the right track with Mr. Anisi initially, they went out and they got an arborist, because here's his letters, there's his affidavit. They seem to have gotten an arborist who is going to go out and give them what they need so they can circumvent all of our ordinances and just rely on this and claim that 26 trees are a danger on an empty lot. Now, the other thing that the statute does not say, it doesn't say anything about zoned residential. And it's going to be up to you as the trier of fact, because we don't have any case law yet dealing with this particular ordinance. And oddly, some other attorney on a Tampa case with tree cutting claimed that on a residentially zoned, that on a non-residentially zoned lot, they still got to cut the trees because there were trailers on it. Now they're doing the opposite argument. It might be zoned residential, but there's nobody living on that property. So if we just use the generalized term residential, not zoned residential, not future land use designations, but residential. This is not a residential lot. There isn't a single house on it. There's not even a tent. So it could not possibly be a danger.
Just a second.
Can I ask a question?
Sure.
I don't know much about, the courtroom, but I think most people say that eyewitness testimony is a powerful evidence, right?
Yes, sir.
Okay. Now, I've done a lot of clearing lately myself, so it's real fresh in my mind. And agricultural property, no problem, okay? And so he says that these 28 trees were fine. And when you look at a tree, when it's been recently cut, you can tell pretty easily, pretty almost for sure, if it's good or not. Because no defects, no rotting, all that kind of stuff. Because I've done enough, I know what it looks like. And so with this eyewitness testimony, he's telling us that those 28 trees look good. And I tell you, I'll bet money on it, from what I heard. Then that affidavit cannot be correct. Now, again, your argument is perfect in a way, but I do not believe what he said. And that's what the whole thing comes down to. I mean, obviously it's residential. It comes down to believing the affidavit. I don't believe it, period. End of story. There's nothing else to talk about, I don't think.
I appreciate your comments, sir. Unfortunately, the statute does not require any purview by the city arborist. Everything that he said, you may not take into consideration. Under the statute, you may not do it. I know you don't like it.
The statute
It
says.
is what the statute says.
No, it doesn't.
It is.
It
Okay,
does
stop. Okay, we're not going to sit here and argue with each other all night. I do have a couple of other questions. Normally, whether you're taking trees down or not taking trees down, or whatever you're doing with the development, normally a site plan is submitted first to the city. Has the site plans been submitted to the city?
The testimony of Mr. Anisi was that no development plan was submitted to the city, that he got a sketch early on showing that they wanted, I think, 40-some townhomes. It was just a diagram. I have it here, but there was no reason to put it into evidence, but it doesn't show any trees.
Right. And he also testified that at some point they did get approval from Hillsborough County to go higher density.
Correct.
But no site plan, no development plan has ever been issued to the city for the city's approval.
Yeah.
Well, David, can I just have one follow-up question,
Sure.
please? Our arborist over there, I just want to make sure that I'm thinking right, that the 28 trees that O'Brien referenced is the same 28 trees that you referenced, right? And you said that you feel almost sure that they were healthy trees, right? Yes. So I just make sure I got my facts straight. Okay.
And that's the other point. We don't know what trees or what location any of these were. We don't know whether half of the ones listed on Mr. O'Brien's October 19th dated letter are ones still standing there and they cut others? We have no idea because there's no identification as location of a single one of these trees. So we don't know we don't know who the tree cutters were. If I did, I would have had them in here and we could have asked them, but I don't know who they are. But the last point I do want to make before any more questions is, again, the common sense is that the owner obtains the documentation from the certified arborist before he does his deed. That's just common sense. It doesn't mean cut, go find an arborist later. And October the 19th, 2020, it's very odd and suspicious that on October the 19th, he suddenly lists the correct address that was never assigned to this property until January the 12th. And that was our testimony. Mr. Anisi asked that, and the city's the one that assigns those addresses, asked that an address be assigned to this vacant lot, and it was done on January the 12th. So how in the world did they come up with an October 19th letter with a non-existent address that suddenly, and as I said, this was not given to us by the property owner when Mr. Ferris was dealing with them. This was emailed to me suddenly by counsel here. And where did this come from? It suddenly has the address on it after we cited the property owner and gave them the correct address on their citation.
Was there any way in October of 2020 for anybody to know what that address is?
I'll defer to Mr. Anisi.
That parcel did not have a physical address.
Wait, so.
Wait.
Let's
Just wait.
finish this.
Let him finish his answer.
Yes, that parcel did not have a physical address, so I had to request through the GIS GIS staff in City of Temple Terrace to assign an address for that parcel.
So in October 19, 2020, there was no way for anybody to know what that address would be?
No, sir.
Thank you.
So our contention is, under the statute, it has not been complied with. It does not provide them a defense to the ordinances we have cited them with. They needed to comply with the ordinances because there was no residence on this property. We contend it is not residential property. It could not possibly present any danger to persons or property because there was nothing there. And yet they left up dead trees that leaned over onto the other property. So, and that the owner did not have this documentation at the time that they did the cutting because this arborist report is just bogus.
Well, and that's kind of what my.
Just wait. Wait, please. One at a time so we can get the record straight. Did you have a question?
Yeah, so I mean, to me, it seems like it all goes down to the validity of the arborist report. Shouldn't, I mean, if it's valid, then I'm kind of in agreement that it's outside our jurisdiction. If it's found to be not valid, though, then that's when we would have to make a decision.
Or do we?
But I mean, so does that need to be verified first? Does it need to be found whether that arborist is truthful or lying or anything?
I think you heard evidence that there's no way he could have known what the address was.
Right, well, that's what I'm saying. There's questionable information on it, so.
Sir, you had the floor.
My point of order is directed towards your counsel, your board counsel, to caution city council that she is coasting dangerously close to a contention of libel and slander against a certified arborist, and I would caution you to be very careful with your words, how you proceed.
I don't say that the arborist put this out at all. I don't know who put this out because he isn't here. If they wanted to present an arborist report and affidavit, bring the guy in. Then we would know.
Statute does not require that.
Samir.
Yeah, let's
Chairman, if I may, I'd like to be very clear that my role here is to counsel the board, not to communicate between attorneys. If any member of the board or the chair has any questions concerning the legality or, the sufficiency of these proceedings, you can ask me. But I do not dialogue between attorneys. Thank you.
Samir, you had a question.
I have a question for you, Jorge. So the counsel, defense counsel, maintains that we have no jurisdiction. What have you to say about that?
Well, what I know of the statute that has been presented today, the statute being the Florida legislature's word on this, is that it in fact creates a limited preemption from not a board, but from city government to require permits for pruning, cutting, and other activity on properties, on residential property. The issue that is not been decided by any of the Florida courts, nor is it defined in the statute, is what is residential property within the meaning of the statute. Residential property is subject to the argument, as one attorney for the city presented, that there being no residence there, it is not residential. There's also the counter argument, as presented by the attorney for the owner, that being zoned residential, it is residential. Well, the statute doesn't say. And what happens today is the board will make a decision on that basis, on what you feel residential should be in context of this argument, this set of facts. The remedy of either party, if you go against their interpretation, is to take this matter on review to the circuit court. And subject to the jurisprudential process, a decision will be made as to what the statute means when it says residential property. Does it include zoning? Does it require a dwelling? The statute right now doesn't say. I do not think that the board is preempted from, having heard this case, making a ruling based on the facts presented to it and the arguments made.
Mr. Buckley, you had a question.
Yeah, I do. Mr. Martin, and also for you, Chair, are we in the end accepting the O'Brien's tree service and stump grinding as evidence in this case?
If it has been presented to you and marked as an exhibit, you can consider that.
But we need to formally accept it into
It's
the...
been accepted as evidence. The weight that you give it and the veracity and even the authenticity of it
Up to mine.
is up to your,
Okay.
to you.
My other question, and this is also for Mr. Martin, it is my, I guess, interpretation that the mandate of this board is to opine local law and not state law. I'm certainly not qualified to opine all of state law. I'm up here to consider local cases that are presented to me according to our municipal code enforcement. Is that your understanding of how I should be interpreting this case?
No, local administrative boards are not only charged with enforcing local ordinances, but they also have to be cognizant of state statutes, constitutional provisions, and that has to be taken into account. You cannot simply blinker the focus of a board to simply what ordinances are enacted by municipal government.
Rod, you had a question.
So from what I understand, the way the owners of the property attorney is trying to explain is if he obtains an arborist, he can start cutting the trees and do whatever he wants, but then our staff from the arborist and the code enforcement, when they walk into the property and they ask, why are these trees being cut? Shouldn't somebody be ready and say, okay, here's what we have? Did that happen? Did that happen?
Well, it did, but it was,
Did they tell our code enforcement, oh, we have this arborist that determined this 28
he was
trees?
giving a document that had, had an address on it that was, that was not, it was really wrong. It wasn't just a block, a house away or a parcel away. It was really wrong. And then at some point, when did you get this October 19th document?
It's an email she got.
Just a few days ago.
So a few days ago, this October 19, 2020 document shows up with the correct address on it, that there's no way they could have known what the correct address was in October 19, 2020, because it hadn't been established yet. So either this guy was Kreskin, or the date of this letter doesn't appear to be factual.
Board, for the record, I was only hired a few days ago, so that was my first communication.
Okay, yeah, no, I'm not blaming you. I'm just saying that it's impossible for Mr. O'Brien of O'Brien's Tree Service to have known that the address of the property was 8903 North 78th Street, Temple Terrace, Florida, on October 19, 2020. It was impossible because the address hadn't been established yet. So your job, gentlemen, is to weigh the evidence as to the weight you give it, the veracity you give it, the authenticity that you give it, and to make a decision as to whether or not a violation has occurred. Now, my question to you, Mr. Schoen, is what is it you're looking for?
We're looking for a finding of guilt, a finding of violation of the 3 ordinance sections that the property owner was cited with, which we've submitted to you. I believe they were our second exhibit. And then a fine. And we're looking for a fine of no less than the $93,000 that they would have had to have paid based on Mr. Ferris's calculations had they gone the proper route under the development code. However, if you find that that's the minimum. If you find that they really did something wrong and you want to give the penalty amount is at least 1/2 of the calculation that was made by Mr. Ferris for penalty, which I think turns out to be somehow $440,000. So.
$445,000, $444,000.
I have one more.
And the other thing that we had cited them with, and the reason why that allows you under Florida statutes as far as issuing a fine, is that it is irreparable. They're irreparable and irreplaceable. So that allows for an increased fine because the damage is done. They're dead. There was no way to fix this.
Mr. Snelling.
The question for Mr. Martin. Sure. So the way you described it earlier, the crux of the decision for us is whether this is a residential property or not a residential property. However, my main problem is with the validity or the authenticity of this arborist report. Do we have any recourse, or where do we fit into that picture?
At this proceeding, there is no involvement of the arborist, and there is no vehicle to challenge that veracity. You have no witness before you. However, you did state correctly that before the board proceeds, it must reach some decision as whether this is treated as residential property in the statute. Again, you have a term in the statute that's not defined, and the board is going to have to conclude as a matter of fact. And
forgive me, but I think it's more than that, because the statute says you got to have a certified arborist report. If we determine or decide that this is not a official arborist report, because there's no way he could have known what the date was in October 2020, doesn't that make his entire argument null and void, because he doesn't meet the statute because he doesn't have the report? He's got a report that by all appearances doesn't appear to be factual, other than maybe the trees are right, but the date certainly can't be October 2020, because there's no way he could have known what the address was. So if this piece of evidence is determined to be not factual, doesn't the whole idea of whether it's residential or not kind of isn't that a moot point?
It is not for the following reason. Again, as I said earlier, this board is not preempted in any way, shape, or form by the statute. The city is. The municipal government, local government cannot require, and they're not even entitled to receive a notice of that certification. However, in this case, the threshold that you need to cross in order to determine whether you're going to look into the veracity of this document, the sufficiency of the evidence, or the weight that you put on the evidence is going to hinge on a determination that that statute does not address this property, which had no dwellings on it, it was vacant, and the only basis for finding that it falls within the limited preemption is going to be, is it sufficient to be zoned residential? That is a question that is threshold and possibly cannot be resolved until this proceeding is completed. If you were to find today, you know what? We think that residential zoning preempts the city, you go no further. That's it.
You what?
You go no further. If you were to find residential property and residential zoned are different, the statute only speaks to residential property, the city is not preempted, therefore now you can go ahead and weigh the sufficiency of the evidence and consider this case.
Yes, sir.
I heard what you said, but I think most of us don't agree with that, whether it's right or not. I hate to say that, but I think it's the truth. But at any rate, I'd like for the arborist to say that you agree or do not agree with what I said, and within, mainly. What I said was, you said that the trees seemed to be healthy, the 28 trees, and the report said that they were not. So I just want to hear what you would say about the fact that the veracity of that, because that's what we're all thinking.
Yes, based on the stumps that were there and the condition of the stumps, there isn't any evidence of any major decay or rot in it. They're hard, solid stumps. So yes, he calls out specifics on decay and rot, but it's just decay and rot. But where's the decay and rot? Is it in the center of the tree? Does he know it's in the center of the tree? It could be a limb or two that's decayed and rot. It's very vague, even though he does get specific trees. But what conditions are that decay or a limb that might have a cavity in is enough to justify the whole tree? When you look at the stump and it's a solid stump without any rot, you're going to have black, rotting, decayed middle.
I've seen them all.
You've seen it. So yes, to me, what was out there doesn't match what he's saying, or his isn't as specific as maybe it should be to justify the removal of that tree.
Board member,
Can
I ask that you not consider this testimony because it's not what the statute calls for.
Can I ask you one other question, Joe?
Go ahead.
Just, do you have any idea when this picture was taken, the Hillsborough County, how recent this picture is?
I believe,
I know it says 128, but I assume that's when it was pulled off the website. But as far as how often does the
yeah, it was when it's pulled off the website without verifying. I believe they update every year. The newer aerials are the first of the year. This one hasn't been yet.
Okay.
But I would have to verify that.
But within the last year, anyway, probably. Yeah.
Thank you. This is for Mr. Singer. So this is a two-part question, actually. So number one, what are you asking us to do? I think I know the answer to that.
I'm asking you to dismiss this action based on state law.
Thank you. Number two, do you know why the owner, your client, did not go through the usual, a process with the city of Temple Terrace?
They believe they were complying with state law as written.
Right, but did they know that the city was telling them something different?
I don't know if they knew, and if they did, it wouldn't be relevant because state law.
Correct, correct, got you. Why did they meet with the city the first time?
I don't know.
All right, thank you.
I have one more question. Is the dead tree listed on that arborist report?
Which dead tree?
The dead tree on the property?
That is remaining?
Yes.
I don't know if it's listed, and I don't, and cannot say, and neither can anyone else in this room say, if it's a danger to person or properties. So could it stay there being dead and not be a danger? Of course.
It's obviously, you know, it's to the end of the property, closer to a residential area, but I don't know.
Any further questions? Go ahead, Bill.
Prior to making a motion, I'd just like, Pam, if you could go over, or Mrs., I'm sorry, could you go over the penalties again? I know there was a $93,000 fine for one set of circumstances, and there was a $988,000 fine for another set of circumstances, and that was halved. I'm not clear on.
The $93,000 was not calculated for purposes of fine. If the property owner goes through the regular process under our code for submits a development plan, Mr. Ferris's testimony was he would have done, and then actually did, what he normally would do would be to take the tree survey that should be submitted by somebody wanting to do a development, and you do an overlay on what it is, the building that they're proposing to build. And he gets to then see, all right, I've got to take out all these, or the developer needs to take out all these trees where they want to do their construction. And there's a formula that he uses that he testified to, where he then calculates what the mitigation is in order to take those trees out legally and build. And if the property owner had done what they were supposed to do, his calculation was, based on the trees removed, was 93,000 even?
93,300.
That's what they would have had to have paid to just do things the normal development way. If someone instead removes trees illegally without getting a permit, let's pretend they didn't get an arborist, but you still got to get a permit under our ordinance to remove trees. If you do that and you don't get a permit, there is a penalty calculation instead. It's different than with developing. And the penalty calculation here was $988,000.
988,800.
Okay. So then he came up with there's another formula that he applied where when he finally wrote and sent the email to the property owner and said, hey, this is what you've done and this is the penalty, he let them know that it had to do with planting some and paying for others into the tree fund.
Yeah, in the code under the penalty, one of the stipulation is that 50% of those trees that would take to replace what they removed illegally would have to be replanted on the site, meaning the other half of that would then have to be paid as a penalty. So that's where the 444,000, I believe it is, comes from, assuming that they would replant half of that on the property. Back.
988, so it'd be 988,800 divided by 2, right?
494,000.
Yeah.
94, yeah.
So let me,
It was 490.
let me follow up on that. So under the normal process that city follows, the minimum they would have paid under mitigation is 93,000.
Yes.
That couldn't be any less.
It could be less, and
How
that's
so?
where that total numbers, I'd have to check my notes, 300 and some trees, I believe it would have been.
311.
To replace what they took down. That would be the equivalent of the sizes of the trees. It would take 311 trees to replace the total sizes of what they removed. They could reduce that number by planting. So if you, just a simple site, they got 10 trees they're taking down, they can replant 5, then 5 of them have to be paid
And do they need to plant them on the site or a different site?
on that site. So you can reduce that number and that total mitigation by replanting a minimum of 3-inch DBH trees on the site. The difference of what you can't plant then is paid into the tree fund.
Thanks. Question for you, sir. And maybe you don't know because your client's not here and you just got hired 5 days ago. What is your client's future plans for this? Are you still planning on building townhomes, or does he still plan, what do you know?
So my understanding is yes, they plan to move forward with building townhomes on this residentially zoned site.
And they plan on following the rules that apply to Temple Terrace?
They intend on continuing to follow the rules issued by both the state and the city.
Okay.
One more question.
Go ahead, Rod.
For our arborist, how did we determine, without getting even a site plan, did we get a site plan or just a preliminary plan or any?
To determine
The amount of trees?
penalty?
Yeah.
Yeah, it was based on the stump that was there, the diameter of the stump, and then using a chart from the Department of Agriculture, that would, with that stump size, you can determine then from that chart what the DBH would have been at breast height. So then you take that, and that's where you use the formula to determine how many trees it would take to replace that one particular tree.
Okay, I have another question. So if you go with your half penalty calculation, the 494,400, does that already take into account any trees that they might put back onto the site? Or would that, if he were to put additional trees on the site as part of the development, would that come off the 494? Or does the 494 already take that into account?
Yeah. Oh, sorry.
I'm sorry, so are you saying that he has the option to reduce that by replanting?
Yeah, under normal circumstances.
Under normal well, that 400, that's the penalty.
Right.
But your normal mitigation, that goes back to that 93,300.
Right.
That can be reduced, that amount, by the number of trees they replant. Again, if they had 311 and they can plant 20, then it's.
But if we're looking at the penalty number, the 494, 400, does that get offset by any trees that they would ultimately put back onto the site, or no?
No.
Okay, thank you.
I thought that's what you said, that.
No, half of that originally. So the original, yeah.
988, 800 was the full.
And according to the code in there, under the penalty, half of it could be replanted back on the site, which I think it was 3,200 some trees.
Right, so if you give him the benefit of the doubt and say he can find someplace to put half of those trees,
1,500 trees.
yeah, then it would only be 494.
penalty.
So it does in effect take into account replanting trees,
Yeah.
but there's no way in hell he's gonna be able to put 15.
Not if you're going to turn around and take them down to put townhomes up.
Yeah, okay.
You asked what we were looking for. We would also, if you're going to make a finding in the city's favor, we had cited this as each tree as a separate violation, and we would ask that you make that finding, and that again, that it was irreparable and irreplaceable, and that each tree is a separate violation, and the maximum amount of fine under the statute is $5,000 for each irreplaceable or irreparable violation. So that's another possible calculation for you. And I wanted to make it clear, though, because I think that before your counsel and maybe the questions, you're misunderstanding what I've been saying. Our case does not rely on you finding that this is residential or not residential. That's only one factor. Even if you find that it's residential, we are still contending that the statute was not fulfilled to give them a defense because they did not obtain the documentation at the time that they cut the trees. So really, we're not relying on a finding of residential or not residential. Clearly, if you find it's not residential, then the statute just doesn't apply for them at all.
So, can I ask,
Sure.
the $5,000 per tree, you said that's in the code? Or is that what
That's what's allowed by statute.
okay. And how many total trees are you saying?
26.
26 total?
26 total and 11 grand.
Oh, 26, so 31, 37.
37 total?
No, that includes the 11.
That includes it, okay, so 26 times, so the options, if we were to find it in the city's favor, is 130,000, 93,300, 988,800, or 494,400. If we find in the city's favor.
I didn't hear that. What was that?
So the options that have been presented to this board for consideration, should we find in the city's favor, is 130,000, 26 trees times 5,000 per tree. The mitigation of trees of 93,300. The penalty of 988,800, or half the penalty, assuming that half the trees would be put back onto the site, of 494,400, if we find in the city's favor. And if there's no further questions, I will entertain a motion.
I have
Give it a oh, you want to
a
go?
question, yeah. October 20th, 2020 is the date the trees were cut, correct?
Well, we don't know.
We don't really know.
We know when we found it.
Well, here's what we know. We know that in December they went out there, right? And found out the trees were cut. At that time, our arborist was given a letter dated October 26th for an address that was not anywhere near the site. Sometime in the last 5 days, this particular letter appeared in Ms. Shoshone's email inbox dated October 19th, 2020, with the correct address that could not have been known on October 19th, 2020. That's what we know.
Yeah, I agree with that sentiment that this O'Brien's tree service and stump grinding October 19th dated document seems weak. And then looking at this, backup document, the affidavit of Edward O'Brien, like.
Well, let me just stop you right there. We're gonna look for a motion, and then we're gonna have discussion of the motion. So if
I just wanted to also point out that this document isn't even filled out correctly. The boxes aren't even checked in the bottom. So if you were to, I feel like both of these are, like, not admissible.
Okay.
Because, like, they're
Well,
both bad.
They're admissible, but the authenticity and veracity that you give them is up to you. So if there's no further questions, I'll entertain a motion. If there's discussion afterwards, then we will have discussion afterwards, but I am looking for a motion at this time.
Let's get the ball rolling here. So I don't have a script for this, but I'll try and use one of the ones that we have for other type of violations.
And just as a reminder, the city is saying that this is, what was the wording you used, Mr. Shum?
That it was irreparable and irreversible.
Irreparable and irreversible, if you find in their favor.
All right, so in case number 21-0256, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code exist on the property located at 8903 North 78th Street. Code violations, section 12-768, subsection A, subsection 1, and code section 12-768, subsection A, subsection 2, and section 12-768, subsection B. This motion is based on the sworn testimony this board has received from Code Enforcement Officer Jose Silva, along with many other witnesses, along with any evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. It's upon considering the following factors: gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations, I move that we have a fine of $130,000 lump sum.
Okay, we have a motion. Do we have a second?
Sorry, what was the number?
130,000. 26 trees times 5,000 per tree.
I'll second that.
We have a motion, have a second. Any further discussion?
Yes.
Go
Yes.
ahead.
The question is,
We'll start at this end.
he had mentioned 93,000 as a minimum to begin with, and so, but I'm okay with just that. But I want to hear from David what you had to say. I thought you were saying there should be the 93 plus the 130 plus maybe even.
No, the options that we were given is to calculate it based on 26 trees as individual violations at 5,000 per tree, which gives you $130,000.
Oh, that's in the other fees are just other
Yeah.
fees. Yeah, okay.
With a finding of irreparable and irreversible.
Right. Did you?
I should have thrown that in there somewhere. I didn't know where to fit
Well,
that in.
he will amend his, if it's acceptable to the person making the motion, he will amend that to include that language now.
Yes. Please include the language that is what irreparable and irreversible
Irreversible.
damage.
Okay, so we have a motion, we have a second. If,
I second it.
and is there any further discussion by this board?
Correct.
Go ahead.
So I think if the defendant went through the normal process through medication, which is the city is saying the normal process being at $93,000 and some change minus how many trees they plant on the side. So it'll be a little bit probably less than that. Let's say they plant, I don't know, 100, would you say? 50? I don't know. How many can they plant on the side, do you think?
Well, the arborists would.
We're past testimony at this point.
All right, so if they would have gone through the normal process, maybe they would have paid $50,000. What do you think, board member? You think that's fair to say?
I thought the number was 93 that we.
Minus,
Whatever mitigation.
Whatever mitigation.
Exactly.
The number, the motion is 130,000, irreparable and irreplaceable.
Yeah, I mean, am I being asked to?
You're not being asked anything. If you have a comment, you're welcome to make a comment. Any other discussion? Okay, obviously, you guys know I don't normally.
David, I think it's 130,000. That's very minimum for what's happened. That's very, very reasonable.
Okay, and I don't normally weigh in on these discussions, but I think we do need to address a couple things. One is, I don't believe that the intent of the statute was to allow developers to simply clear cut any individual piece of property they wanted to, and then come in after the fact and find some arborist to just give them a document. I don't believe that was the intent of the, and I will agree that there's probably some tweaking that needs to be done to the statute, but I don't think the intent was to ever allow a developer to come in and clear cut acres of land. Even if you were to take that interpretation, I think a lot of the evidence weighs on the fact that there is no way that Mr. O'Brien could have known the address at the time he supposedly wrote this letter in October 2020. So there was no, let me see what the actual document says here.
8105?
Yeah, hang on a second.
Add-
There was no documentation from a certified arborist at the time the trees came down, because there's no way he could have known the address at that time, and the only document that it was given to our arborist was for some other property. So I think that weighs heavily, and I don't personally have a problem with the 130,000. Any further discussion?
Yeah, let me just say, I'm open to changing that amount. I
don't think
put that number out there just to.
I don't think you need to.
get it
Nobody's
out on
asking
the
you.
table. Okay.
Nobody's asking you to do that. Okay, any further discussion? All those in favor?
Aye.
Opposed? No nays, motion carries. So just to be clear, sir, the board found in favor of the city and has fined your client $130,000 and found them to be irreparable and irrevocably in damage or in violation of the statute, of our code.
Thank you. Board, do I receive a written copy of the order?
You will. I can't tell you exactly when, but you will get one. Do we have any other cases this evening?
We better not. Oh my God, we do.
we better not.
Hopefully they're not here.
Might have to run through some.
Okay, just unfinished business. Case number 25214, City versus Timothy Tibude for the property located at 113 Glenridge Avenue. Deadline for compliance is tonight at midnight. And then after that on the agenda, it would just be at the bottom for the election of officers.
Yeah, before we do that, I do have one item of new business, and as soon as I find my spreadsheet. I don't know, a week or so ago, I asked Kristen to give me, well, let me back up. At our last code meeting, I neglected to bring up, under new business, an issue I had with at least 3 properties that are on our lien list. Three larger properties that have lien amounts of $190,000, $170,000, $179,000, and $460,000. So I wanted to bring it up now, and I apologize. I know it's late, but I don't want this to have to sit until the next hearing. Today, by chance, I also received a phone call and an email from Annette Rennie about one of these addresses in particular, 9408 Hidden Ridge Place. She did send a copy of her letter to the assistant city clerk and also to our city attorney. If it's appropriate, I'd like to read that into the record.
There's no reason why you shouldn't.
Okay. It's very short.
As long as it's short, yeah.
Yeah, it's short. Let me just find it. Okay, February 10th, 2021. My name is Annette Rennie, 9512 Woodland Ridge, Temple Terrace, Florida. I have lived in the neighborhood since 1994. The home on Hidden Ridge has been a constant problem. Rats, overgrowth, dry wood rot, and long grass and weeds. Mold all over the back of stucco and screen porch. There have been many code violations with no positive outcome. Neighbors have occasionally mowed the grass. Even our code director has mowed. Has mowed it. I'm sure he is tired of complaints with no outcome that will help. One neighbor has put plywood on top of his fence to help separate his home from this house. Nothing has helped, and this continues to go on with no positive results. This is not a hardship case. Nobody lives there, and the owner refuses to comply. I can compare this easily to River Hills a couple years ago. This is dangerous, it's not healthy, and it's time to go a step further and look at foreclosure. We should not have to look at this or have this property in that condition sitting in our neighborhood. To continue sets a precedence. I am asking you to take the next step and look at foreclosure. The owner will not comply and never has. Thank you, Annette Rennie. It's, again, just by happenstance, I was going to bring that particular property up. There is actually 2 cases against that particular property. One with a lien amount of $179,575, one with a lien amount of $170,625. The daily fine continues on one of the cases at $150 a day, the other one at $125 a day. That particular property, along with the property at North 52nd Street, owned by Coy Lee Berry Jr., has a lien amount of $190,000. And there was another one that has an asterisk next to it, which I don't know what that means. I'm sure Mr. Schoen or somebody can explain that to me. At 7604 Leon Avenue, owned by Christopher York, with a lien amount of $460,000. Homesteaded property, okay. So obviously there's probably nothing we can do about the homesteaded property. But the other 2 properties, that one of which has 2 very large case numbers against it, I'd like to see what this board would like to do about it. One of the options certainly is to move towards foreclosure.
I agree.
Or the one that Annette Rennie wrote us about?
Well, there's 2 similarly situated. You've got 9408 Hidden Ridge, which has, again, 2 cases against it, one for $179,575, the other for $176,25. And then there's another at North 52nd Street, owned by Coy Lee Berry Jr., with a current lien amount of $190,400. Now there's other properties, but those are the really big ones.
Since I've been on the board, we've never
We've
never foreclosed, and so I mean, I'm not even 100% sure what the process is.
I think we have the option of asking them to do it.
We do, but
If you recall, back in the day, I created, I believe, a motion for you. Hopefully, we have it in the packets that would be requesting the city attorney's office to investigate.
I'll have to go back in the day.
Hopefully, yeah, as luck will have it, probably it isn't in your thing, but,
sure
the gist of it is that the board had decided that what they would do in this case to get the ball rolling would be to make a motion to have the city attorney's office investigate the possibility of foreclosure and then report back.
So again, if that's something the board would like further information on, would like the city attorney to further investigate, there should be language. You found it?
Yep. Does it mean I own it?
You own it.
All right, so,
Yeah, I do, David.
Sure.
Were all three properties that Annette or Ms.
Well, there's
Rennie-
two properties. One
Did
has
she
two.
message you about? Was it 2 or 3?
It's two properties. One has two cases against it.
Oh, okay. So are all the properties that she mentioned already with a case number matching?
Yes.
Okay. So she's
Yeah,
bringing
so
up.
that, so that the one at 9408 Hidden Ridge has two cases. And if somebody's going to make a motion, you might want to write this down. It's case number 17-2613 and case number 16-2397. The other property that's not homesteaded is 10014 North 52nd Street, which would probably require an additional motion if you so desire. And that case number is 15-2510.
okay. What was the address of the Hidden Ridge one?
Hidden Ridge is 9408 Hidden Ridge Place.
Okay,
I just wanted to understand, same property has two liens?
Yes,
Two different violations.
two different cases, yeah.
Cases.
Yeah, one in, I guess, 2016 and one in 2017.
all right, I'll make a motion if we're ready.
Sure.
All right, so for the property located at 9408 Hidden Ridge Place, which has pending code enforcement liens in cases number 17-2613 and 16-2397, I hereby move that the city attorney investigate the possibility of commencing foreclosure procedures against the property and report back to this board with her recommendations at the next scheduled board meeting.
We have a motion, do we have a second?
Second.
Any discussion?
I do have one thing to comment
Okay.
on, and that's, I know in this case, Ms. Rennie came to you via text, and I think.
Email.
Wouldn't it be standard procedure that she reach out to Mr. Baroni and not you as the chair of this board?
She actually reached out to, initially reached out to Assistant City Clerk, and then reached out to me because Assistant City Clerk said that because it was not, because we are a quasi-judicial entity, that she couldn't approve it to be read into the record. That request went to Ernie. When Ernie came in tonight, I asked him, I said, I got this request that was sent to you, and he's familiar with it. He got it before I did. And I asked him if I should mention it during our upfront quasi-judicial whatever, ex parte communications. He said, no, you can wait till new business, which is what I did. And then I asked permission to read it into the record, which you witnessed, and was given that permission.
Okay.
So let me follow.
All right,
Oh, go ahead.
Just so it doesn't look like I undercut Ms. Garcia, just so you know, kind of my conversation with Ms. Rennie earlier was, she thought that case was on the agenda for today, and it was not, and then I, advised her that being a quasi-judicial board, there's no room for public comment on, like as if it were city council or something.
Right.
So I just want to let you know, and then when you brought that up to me, I felt that since you had already known about it, you wanted to bring it up, new business would be the appropriate place to do so.
And the reason I brought it up was just because I wanted to make sure that it wasn't, that a resident was getting in touch with you to bring up something, a potential violation, but that's not the case. It appears it was already something that was brought up there, just merely asking that we hear it.
Yes.
Okay, thank you.
So what about the situation with the second property? Was there no
There was,
complaint?
no, I haven't heard, I mean, I had planned, as I stated earlier, I had planned on bringing these three cases, two properties up at the last meeting, and that meeting went long, not as long as this one. And I just, it slipped my mind, so I had always, and it just was by happenstance that Ms. Rennie, mentioned it to the city clerk today.
How long has that property been in violation? This is
Since
2015?
Since 2015. So we have a motion on the floor, we have a second. Is there any further discussion? Seeing none, all those in favor?
Aye.
Opposed? No nays, motion carries.
Does anyone else have the foreclosure thing?
I don't.
Would you like me to read it?
If
You got it?
Go for it, Bill.
It's up to you. All right.
And just again, for the record, I've not had anybody ask me about this particular property at North 10014 North 52nd Street.
For the property located at 10014 North 52nd Street, which is a pending code enforcement lien in case number 15-2510, I hereby move that the city attorney investigate the possibility of commencing foreclosure procedures against the property and report back to this board with her recommendations at the next scheduled board meeting.
We have a motion, do we have a second?
Second.
Any further discussion? Seeing none, all those in favor?
Aye.
Aye.
Opposed? No nays, motion carries. Thank you, gentlemen, that's all the new business I have. We do have a couple of other items, the election of officers. The first is for the chairman. I need a motion to elect the chairman for, how long is the term?
A year.
For 1 year.
I nominate David Pogorelic.
Make it in form of a motion, please.
I move that what would be the motion?
Motion that David Pogorelic continue as chairman.
Okay. I move that David Pogorelic continue as chairman of this board.
We have a motion, do we have a second?
I second that.
Any further discussion? All those in favor?
Aye.
Opposed? No nays. Next is for vice chairman, and if, again, I don't normally get involved in this, but I would like to have someone move that Samir be the vice chair. He has shown his dedication by coming to every single meeting, even when we started this with the COVID and everything, and has shown his dedication to the city and the people that come in front of us. That would be-
David, I'll make that motion. I agree that Samir would be great for that.
Okay, thank you.
position and Would do a great job. So I'll motion that Samir be the vice chair of the MECB board.
Okay.
I second.
Assuming he wants it. He's not, no, we haven't given him a chance to say no yet. Certainly, if, why don't you just hold that a second? Give him an opportunity to say yes or no?
Well, thank you, David. This is a surprise, obviously.
Now, just as a way of convincing you, there really isn't anything for the vice chair to do unless I don't show up.
Okay.
Okay? If I don't show
not
up,
planning-
no, I haven't missed a meeting in since I started here. I've never missed a meeting. But if I don't show up, then you will be acting chair. You will get a book like this that tells you exactly what to do.
And you have to wear a hat with a thing that
Yeah.
spins that says.
And you get to you get to bang the gavel.
My head, so you have to wear it now.
Get to bang the gavel, and you get to shush people and do all that stuff. So anyway, but certainly, it's your decision. You're not required to say yes. You can, it's up to you.
Well, thank you for your vote of confidence, and I hope I will live up to your nomination. Thank you.
Okay, so we have a motion. Do we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Opposed? No nays, motion carries. One last motion, gentlemen. Do I have a motion to adjourn?
Motion to adjourn.
Do I have a second?
Second.
All those in favor?
Aye.
Motion carries. We are adjourned, gentlemen. Thank you for your time and your patience tonight.
I think this is the second latest.
Yeah. We were here till midnight one time.
Yeah. I think it was the Skype call.